Good evening, it's Patriot Smoothie. I am reporting from the Ottawa Courthouse, 161 Elgin, at the end of day 10 for the trial of Tamara Lich and Chris Barber. The wheels of justice move extraordinarily slowly. We ended today talking about how much more time we're going to need to finish this trial. Looking like 2 weeks in October, 2 weeks in November, potentially even going overriding some of Pat King's time, not overriding, but overlapping with some of his time. So logistically, that's going to be challenging to cover both. But that's my problem. That's Chris's problem. That's everyone else's problem. Tomorrow, the Million March for Kids across Canada, starting at 9 a.m. local times.
Yes. Gathering at 9, marching at 11.
Marching at 11, and then the national walkout and everything else going on. Guys, I am absolutely overloaded with information in that courtroom, man. It was a heavy day of legal arguments this morning. Greenspan going over the different, basically the legal arguments the defense has to make, the legal arguments the defense is making to exclude 8 witnesses. Used to be 9, now it's 8, based on the fact that they're just not legally necessary anymore. And also, in one of the counts, the Crown has to prove that the mischief was not committed, and in one of the counts they have to prove that mischief was committed, but that specifically by the accused. Now that's for the counseling, and I believe that the counseling charges are integral to the unlawful design of a conspiracy that they're basically for the Carter application, but not directly for a conspiracy charge. Something brought up earlier in the trial too. And as these arguments develop, and we get resolutions of them, the judge saying that we might even get an answer to the admissions 2 argument by the end of the week, I'll be able to come on here and explain more of those lingering questions that I and you have. I'm certainly not a legal expert, but this stuff gets really heavy sometimes and really dry, and it's nice. Thank you for everyone who's supported us everywhere that you are supporting us from. Maybe tonight I'll hop on and do a casual live where we can interact and talk about things after I've had more time to develop them. Obviously, everyone's really excited for tomorrow. That's showing around here. Everyone's complete. Their minds are not, like everyone who's not actually in the courtroom, their minds are elsewhere. And I understand there's a big thing happening tomorrow. I will be here in the courtroom. Chris Stacey will be on the streets in Ottawa covering that. And of course, you'll probably be able to find it around the country. And then on the 22nd, something there as well. So lots to look forward to in that regard. But me, I'll be right here in court reporting on X and trying to come back with the summaries here. We left off the end of the day again with the discussion of the timing, and we did have Kim Ayotte, but my goodness, he got sent out of the courtroom enough. He even joked at one point that he'd get his 10,000 steps in. He must have been dismissed 5, 6, 7 times from court, as there was different objections from the defense. At one point, Kim Ayotte said something along the lines of that the officer, like he was fearful for his officer's safety, and that the defense objected to that, basically, and the Crown specifying that they're not leading this for the truth. They're leading this basically to establish, the situation in Ottawa, but not for the truth of the content, I guess. So it's not exactly the highest legal weight. We're also, I believe, in a voir dire again. Hard to keep up with where we are and what's going on, but as soon as I know, I'll tell you. Well, that's where it is. It's confusing, but like I said, Kim Ayotte pulled out, and the defense basically saying Kim Ayotte was saying those things. The Crown is asking these questions to make Kim Ayotte, or Kim Ayotte was saying these questions to basically have it disseminated in the public record that he was fearful for officer safety. That's why he wanted bylaw walking with Ottawa police, so on and so forth. There was discussion of a city camera at Metcalfe and Wellington, which direction it was facing, basically. Greenspan pointing out that it says right on the photographs why they were taking. The defense pointing out that actually these images were compiled for the sake of making a civil affidavit for the civil lawsuit, one of the civil lawsuits going on. Very different purpose than the criminal. The Crown saying that everything that needs to be disclosed has been disclosed. The Crown saying that there's nothing that Kim Ayotte is saying that the defense doesn't know about because he testified about it at POEC. But that's interesting because, as Greenspan pointed out at POEC, Kim Ayotte testified he took one walk at one specific time. Now there's allegedly 3 of these so-called recon walks that Kim Ayotte would say to fellow city employees on Microsoft Teams and other places that he was going on a recon walk. And previously testifying that in POEC that there was only one such kind of walk outside most of the time, or out his condo or out his window. He was looking at the famous Rideau and Sussex corner, or he was looking at CCTV from his office or at his condo at home. So where we are with all of this, it's up in the air. I don't know. Like I said, Kim Ayotte kept getting tossed out of the courtroom so that they could discuss these legal issues between the council teams, the council parties, the Crown and the defense. There's a lot of stuff going on. It's not happening with great speed, and it's not, at least another 4 weeks it sounds like, but I don't know if they haven't agreed to that. The defense expressing frustration again, as always, that the timeline the Crown gave nowhere near to what's actually playing out. We're only on the 3rd witness out of potentially 21 witnesses, not moving very quickly, not moving according to schedule at all. That's absolutely true. But the Justice Perkins McVeigh doing as much as she can to keep things on the rails and judging and balancing this tremendous amount of arguments and evidence and just trying to give everyone the fairest possible chance.
So speaking of those arguments, we have, I guess, 3 days left before the break. Are we going to get, do you think, some answers?
Like I said earlier, and I said earlier today as well, the judge says that by the end of the week, she'll try to make a decision on the admissions 2 argument, on the argument concerning the admissibility of 8 witnesses. Now the Crown has stood down one of those witnesses. They only want to call 8 of those contested witnesses. The defense arguing again that those arguments are that those witnesses are no longer legally necessary in the face of their admission, that they can only speak to mischief, and impacts thereof. Very observational and not probative, as they like to say, into that. So nothing to do with the counseling. They never met Tamara Lich or Chris Barber. They never had contact with them. They can't speak to any kind of counseling, and the only stuff that they can give is very general observational stuff that basically belongs in an impact statement, less than in the evidence in the court proceeding. Belongs at the end if and when there's a conviction. So the judge has already made it clear that she would act as a gatekeeper to the witness, and as she said she'll do with all witnesses, as she did today with this witness who's currently on the stand, Mr. Kim Ayotte, Director of Emergency Services and Preparedness for the City of Ottawa, I believe. Preparedness is in there.
So everything but police.
Everything but police. Bylaw, he said corporate security, whatever that is, paramedics, fire, all that stuff. Keeping the roads open, stuff like that. He was testifying about road blockages and so on. And he didn't even get to that. He was testifying about what their plan for keeping a road open was. And he said, well, they would ticket them, and if they were inside of the red zone, they needed police escort. If they were outside of the red zone, they could business as usual, unless if they saw a protest vehicle. And what is a protest vehicle? We didn't get to see that defined. Was it a car or a truck with a flag on it? Who knows? We don't know what that definition is. And in that case, he asked his officers to call the police. He said that belief was reinforced at a police meeting just before the end of January, and then there was some debate between defense and Crown over if that was relevant, because he said it was reinforced, it didn't change his perspective. And again, keeping that evidence and testimony to direct things that the witness has knowledge of or was involved in directly. So reports and emails from other people, so on and so forth. The Crown is in their right to call those people, but the witnesses need to speak to the things they were directly involved in and directly did, and not giving, there's no weight to opinions. Why did you capture this image? The Crown kept asking, of these CCTV images from the late January on Wellington and Metcalfe, and it's basically that they were prepared for a civil affidavit, and that's what the judge understood, that's what everyone understood, and the opinion as to why it was captured isn't significant if it wasn't just it's not like he was at his condo and, as the judge said, he saw something and said, oh, I want to capture that. It was more of a process that maybe, and I do believe, involved the staff. So we're going to get through all of this stuff. There's a lot to go through. I will be back tomorrow from the courtroom. If you want more of the details, go on the X. It's a lot of stuff if you're interested. Have a great night.